नमस्ते फ्रेंड, आप सभी का एक बार फिर से वेलकम। फ्रेंड्स, सुप्रीम कोर्ट का डिसीजन, पीएनबी रेगुलेशंस, बैंक कैन नॉट विथहोल्ड पीएफ एंड ग्रेच्युटी विदाउट प्रूविंग एक्चुअल लॉस caused by employee. Supreme Court. The Supreme Court recently ruled in favor of an employee appellant directing the Punjab National Bank to release the provident fund and gratuity due to him who was compulsorily retired. The court held that as per the Punjab National Bank Officer Service Regulation 1979, the bank could withhold the PF amount only when any loss is proved to be caused to it by an employee's act. In this case, the bank not only failed to prove the alleged loss but also denied a fair hearing to him. Friends, इसमें डिटेल केस के बारे में मैं आपको बताऊं। द सुप्रीम कोर्ट बेंच comprising Justice J.K. Maheshwari and Justice K.B. Viswanathan was hearing an appeal against the division bench judgment of the Calcutta High Court, which denied PF and gratuity to the appellant who was compulsorily retired from the PNB. In present case, the appellant was compulsorily retired as senior manager of the Punjab National Bank after he was found guilty by the disciplinary authority in 2010. As a result, he was denied have encashment, employer's contribution of the provident fund, gratuity and pension. He filed a writ petition before the High Court claiming only the terminal benefits accruing to him but did not challenge his compulsory retirement. Meanwhile, the Board of Directors passed a resolution in 2010 denying his employer's contribution to the Provident Fund. The single judge SC in 2012 directed the bank to pay PF gratuity and leave encashment within 8 weeks. The leave encashment within 8 weeks. No pension was granted since he was not in the service candidates when the scheme for shifting to the pension regime became optional. In the appeal, the division bench set aside the grant of provident funds and gratuity on the pretext that by an act of the appellant, the loss has been caused to the bank. Aggrieved by the same, the appellant approached the Supreme Court. The only issue before the court was regarding the denial of the employer's contribution of provident fund and non-payment of gratuity to the appellant because of the order of compulsory retirement. और जो किन किन मुद्दों पे कोर्ट ने अपना जजमेंट आधारित किया, बैंक failed to prove any loss and denied fair hearing to employee must pay its share of PF. Second point, penalty of compulsory retirement not a ground for denial of gratuity. It's only in the case of dismissal or removal. And third point was opportunity for hearing must be granted before denying gratuity. Moreover, the court observed that the appellant was not provided with an opportunity for a hearing before the gratuity was forfeited. और लास्टली यूको बैंक का एक हवाला देते हुए कोर्ट ने कहा, टेकिंग ए कंप्रहेंसिव व्यू ऑफ द 1977 रेगुलेशन, 1979 regulation, circular dated 16 January 97 and the factual circumstances, the court concluded that the appeal deserved to be allowed. It affirmed the findings of the learned single judge and set aside the judgment rendered by the division bench. Case title ज्योतिर्मय राय रे वर्सेस फील्ड जनरल मैनेजर पंजाब नेशनल बैंक, और इसका डिटेल्स आप लाइव लॉ पे देख सकते हैं। थैंक यू, नमस्कार।